Hey, I'm doing my office hours remote today from Albuquerque, New Mexico, but I'll be back at Columbia self-storage quite soon. You know, a lot of folks were pretty excited about the decision that came out of the Massachusetts court in the Harvard case yesterday, rightfully so, where the court found that the federal government had violated the First Amendment free speech rights of Harvard and had also violated other federal anti-discrimination laws by pressing so hard in negotiations with Harvard and cutting off their funding when Harvard refused to accede to the requirements or the terms that the government was insisting upon. Now, there's been a lot of media about this case, and I just want to point out one thing that I think has been underappreciated, which is that the judge's decision in the Harvard case is an explicit invitation to Columbia, to Brown, to Northwestern, to the University of Pennsylvania, to schools that have entered into agreements already. They didn't fight like Harvard did. They entered into agreements with the Trump administration, surrendering core fundamental values of their academic mission. And what the court identified those values to be in the Harvard case that are at stake in all of these other universities' agreements are things like the right to manage an academic community and evaluate teaching and scholarship free from governmental interference, as well as the university's prerogative to determine for itself on academic grounds who may teach and what is taught in the college classroom. So too, what was at stake in these negotiations between the government and Harvard, but also it lies at the core of the agreements with these other universities that settled, that entered into agreements with the university, was the requirement that Harvard, Columbia, Penn, Brown, Northwestern overhaul its governance, hiring, and academic programs to comport with the government's ideology and prescribed viewpoint. The court goes on to say that the government cannot attempt to control who may teach, what may be taught, how it shall be taught, and who may be admitted to study. I mean, you just read the Columbia Agreement, all of those things are things that the university has surrendered in important ways to governmental oversight, approval, and the terms of those fundamental core missions to the government's ideology or a particular viewpoint. So what I want to urge is that those universities that have entered into those agreements and the AAUP, the American Association of University Professors, that are at those universities, see this decision as an invitation to file suit against the federal government for violating the universities and the faculties and students and staff's First Amendment rights, and that the universities have agreed to basically surrendering rights under Title VI, which they can still challenge. So the fact that they've entered into agreements doesn't mean that they can't still sue the government, even though they did so willingly. The AAUP has independent, what we call in law, standing to bring those lawsuits, even if the universities won't do it, which in Columbia's case, I doubt they will. So it's our job as members of these universities, as constituents of those universities, as citizens, to push the general councils, the boards of trustees in the universities to bring these lawsuits and to work closely with the AAUP, which is an amazing organization and is doing so much work. Vina Dubal, the general counsel, is just working round the clock to defend academic freedom. We need to support the AAUP in each of these institutions in also bringing suit to challenge these already signed agreements. They're unconstitutional, they're illegal, and they're undemocratic.